look at the 2005-2006 Supreme Court of Ghana law report. Now, the consideration. In our opinion, the crux of this application is whether, under the circumstances that the trial judge was faced with, could he have proceeded to determine the mandamus applications would adhere the applicants in the form of affidavit evidence and legal submissions on whether the case before him, notwithstanding non-opposition by the Electoral Commission, was a proper case for the grant of an order of mandamus. It is very clear to us that it was plain to the trial judge that the clients of Mr. GHOne Edwidge Temaklo stood to be affected by the proceedings in the mandamus application. And the least he could have done was to grant them a hearing on the facts and the law upon which the application was brought. Our courts and all courts, especially in the common law tradition, have held this right to a hearing so sacrosanct that under the circumstances of this case, the applicant ought to have been given a hearing, notwithstanding or irrespective of the provisions of Order 4, Rule 5 of CI 47 on joinder generally and Order 55 on judicial review. In the case of Awuni versus West Africa Exams Council 2003-2004 Supreme Court of Ghana law report, the Supreme Court quashed a decision of an administrative body, that is the West Africa Examination Council, for failure to accord persons a right to a hearing. The statute under which the West Africa Examination Council functioned did not expressly confer a right to a hearing, but the Supreme Court held that the West Africa Examination Council ought to have accorded those affected a right, since the right to a hearing had been elevated to a constitutional right in Article 23. If that had been held to bind administrative bodies, how much more a court of law? In the case of ex parte Hawa Yakubu, the High Court in Bolgatanga made orders in an election matter which affected Hawa Yakubu, a candidate at the election. And though she was a non-party, the Supreme Court held that on the facts in the case, the High Court violated her right to be heard and quashed the orders of the High Court. The interested parties say that because Mr. GHOne Edwidge Temaklo was allowed by the trial judge to speak, he was accorded a hearing. But they must realize that he was allowed to speak as a friend of the court, as recorded by the judge himself, and not as counsel for the applicants. This is an unfortunate misunderstanding of what amounts to a hearing in the mandamus application of this nature. Hearing plainly required the applicants to have filed an affidavit in the matter and to have made legal submissions. In this case, none of that happened, so the trial judge violated the right to a hearing of the applicants. Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of Nsawam Adwajiri and Ahafwano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabikwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaikwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Adwajiri and Hafuanon North are not affected by this order, by this our order, and in effect those declarations stand. Despite quashing the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our conclusion on this application, we exercise our powers under Article 1294 of the 1992 Constitution and make an order pursuant to Order 55, Rule 65, to the effect that the applicants herein are granted leave to file affidavits and statements of case in answer to the respective applications for mandamus which have not been quashed. No, which have not been quashed. Those which have not been quashed. They are still extant. Those which are quashed, yeah. Now those which have been quashed, sorry. Those which have been quashed, yes. To file those which have been quashed as interested parties. The time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for the hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court ex parte Agua Company Limited, Auditor General Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, reliefs A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while reliefs A3 and A6 are refused. Reliefs B and C are hereby dismissed. Ordered accordingly.
My lords, we are extremely grateful, We are grateful to the court. My Lord, you are grateful. My Lord, there's a second motion on your docket.
Respectfully, my Lord, civil motion number JA/30/2025. The Republic vs. High Court General Jurisdiction 13, Accra. Ex-party, the National Democratic Congress. National Democratic Congress. Baba Sadi. Arabna Oben. Amenope Philibert Fomi. Ibi Bright. Christopher Bayer. Akwesi Edusei. The Electoral Commission of Ghana. Patrick Yalboama. Nana Ekia Owusu Efriye. Frank Ano Domper. Charles Forson. Martin Kweku Ejay Mensah. Eric Nana Ajiman Efriye. Inspector General of Police. Respectfully, my Lord, that is so.
No, that is the same. And the same representation.
Council, the same representation, Council.
That is what my lords.
There was one change.
Okay.
Let's replace that person with Nana Befi Yeboah. Nana Befi Yeboah. He will replace Nana Ejay Bafo Ewa. Nana Ejay Bafo Ewa. Nana Ejay H-Y-E. 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 Bafo.
Okay, no.
Bafo
Yes. The lawyer,
he's a lawyer.
Yes, and then now MP.
Yes.
MP elect.
MP elect, yeah. Well, for the 2nd to 7th interested parties.
So, Bapwe was replaced by Nana
Befi Yeboah. Malos Befi, BAAFI, and then Yeboah.
Okay. Thank you. So, what is the fate of this application?
My Lord, in view of the fact that the orders we're seeking to stay have been quashed, we will seek leave of this court to have the application withdrawn.
Mr. Menugo.
Yes, my lord.
Any opposition?
No, my lord.
Mr. Dimako.
My lord's no objection.
No opposition, no objection to the prayer of the council for the applicants. The application for stay of execution is struck out as withdrawn.
Extremely grateful.
Give me some little cost.
No problem.
I think when you finish the whole thing, when you finish the whole matter.
The whole matter?
Yes. So you are being moved into all of this you notice that you didn't find any process. And it's understandable because your role is very crucial. The role of the police is very crucial. You see what this application has done. Using legal application that we should be, which is resting, those who resting, we all have to come. We decided that instead of adjourning for a judgment or to give you a ruling without reasons, in order to forestall any unnecessary comments and therefore disruptions, that is why we constrained ourselves and did this. So also play your role as a convey to IGP. You play your role. Neutral persons, and then make sure that we avoid situations which can lead to an escalation of any disruptions. Okay? Okay. Now the political parties, they are not here. There is the lawyers who are. At least there's a general secretary here, Mr. Fifi Kwete. Yes. Yes. We also think, as we are talking to the police, make their work easier. You, the political parties, make their work easier. Try and then also help so that we have a peaceful atmosphere as we go forward. Thank you.
All rise.
Results.